Separation of powers is a political doctrine originated from ancient Greece. This doctrine is necessary to limit abuse of government power. The traditional notion of the separation of power holds that in order to balance the power in a state and maintain the liberty, the division of powers must be preserved. You need to, in an essay question, when you have separation of power essay question, you need to start by defining what is a separation of power and what is the main purpose. You can use similar statements to define the notion. The basic idea, as expressed by Baron de Montesquieu in L'Esprit de Loi, states the following: when the legislative and the executive powers are united in the same person or in the same body of magistrates, there can be no liberty. Again, there is no liberty if the power of judging is not separated from the legislature and the executive. Therefore, as you can see, Baron de Montesquieu has expressed this notion that there has to be separation of powers between legislature, executive, and judiciary. Legislature is the parliament, executive is the government, and judiciary are the courts. They cannot be related to, the same person cannot be involved with all the three parts with the judiciary, legislature, and the executive, that they have to be strictly separated in order for a country to minimize abuse of power. John Locke argued that there can only be one supreme power, which is the legislative, to which all the rest must be subordinate. Separation of powers in the UK Constitution. The UK is a parliamentary democracy. Therefore, there is an overlap between the executive and legislature in principle. However, Constitutional Reform Act has been passed to deal with some of the very obvious problems that pose some risk for UK's compliance with separation of power. We will discuss the Constitutional Reform Act 2005 when we move to the discussion of an essay question on this topic. Legislature and executive. Separation of powers is at its weakest in Parliament and government, as Parliament provides the personnel for the government. So these two are interrelated, which is not very good, because if they are related, if the same people govern those branches, then the chances of abuse of power increases. Therefore, we see fusion of power, which is usually not very good for minimizing abuse of power in the country. Legislature and judiciary is a constitutional convention of the highest importance that the legislature and the judiciary are separate. Therefore, members of parliament do not have any influence on the court. In a country where judiciary is not independent, we usually see a very high level of corruption and abuse of power by the government. Executive and judiciary, both the executive and judiciary can make laws. There is no functional separation of power. Executive decision making has increased in recent years. Now we will go through important cases that you need to know about separation of powers. Smedli Case. It is a constitutional convention of the highest importance that the legislature and the judiciary are separate and independent of one another, subject to some ultimate rights of Parliament over the judiciary. You can, when you have an essay question on this topic, and you have to argue why it is a constitutional convention that judiciary and Parliament have to be separate, you can cite this case. You can obviously make an argument that it has to be separate so that judiciary can make fair decisions and there is no influence from the members of parliament over the courts, but you need to always cite relevant authorities when you make your arguments in your essay questions. That is why we are giving you important cases so that you memorize them and you cite them in your essay questions. This case, Antique versus Carrington, is a very, very important case. It's a landmark case in public law. Make sure that you memorize it and you know very well what is the main outcome of this case. Here, Secretary of State entered a house for search, Antique's house, who was the claimant. And the issue for the courts to decide was if search warrant, which was issued by the Secretary of State, was valid. The Secretary of State has governmental power, whereas a search warrant had to be issued by the court. Therefore, there was overlap of the powers. And the court said that the warrant was illegal. Secretary of State did not have a legal power to issue a search warrant based on any legal authorities. So the main principle here was that interference with the rights of an individual can only be justified on the basis of some lawful authority. If there is no statute or a case based on which the power can be justified, the Secretary of State could not just make up the rule that she or he had a power to issue a search warrant. There was no rule that was saying that she had such a power. Therefore, the entry into Antique's home was a trespass because search warrant was declared void. How did the Constitutional Reform Act 2005 had enhanced separation of powers in the UK? This can be an essay question that you receive on your upcoming exam, because this is a very examinable topic. Most of the times we see questions like similar to this. So make sure that you understand very well what has been done in the Constitutional Reform Act 2005 and why it has been done, why they changed what they changed, and make sure that you have some good arguments to show to the examiner that you understand the reforms and you have an ability to provide critical analysis. First, you need to argue for and against the statement. In this case, if the Constitutional Reform Act 2005 enhanced separation of power in the UK or did not enhance separation of power in the UK, if you have good legal skills, you should be able to argue for both sides of the argument. A law school is preparing you for being a lawyer, and a good lawyer should be able to argue on both sides. Therefore, it is important that you do not stick with just one side of the argument and you provide arguments for both sides. After you provide an argument, make sure that either you support all your arguments with relevant legal authorities, whether it's a case or a statute or academic commentary. You need to cite relevant legal authorities in order for your argument to have to get enough grades for you to be able to get a high grade. Also, you need to make sure that an argument after discussion, make sure you make an argument after a discussion of each relevant law. A lot of times students become very descriptive when they hear about an essay about separation of power. What they do is they just write everything they know about separation of power. I've seen this in many essays, and this is the most common mistake that students make. If the question is asking about separation of power, it will not ask you to write everything you know about separation of power. Legal essays usually have a research direction. In other words, it is asking you a specific question around which you are supposed to give arguments for and against, give critical analysis. I was saying that please make sure that your essay is not descriptive and you support your whatever you say, the overview of the law should be related to the arguments you make, rather than just randomly try to discuss all the relevant laws about separation of power that you've heard. It has to be leading to the point, it has to be leading to the argument. We have on the website a model answer, a high to 1 level answer that you can read. I highly recommend you to read it in detail so that you learn what you are expected to do in a coursework or on an exam to answer these similar questions. This is an example coursework. You cannot copy it because this will be academic misconduct, but you can read it for educational purposes to understand how you should be structuring your answer to get a high grade. We start with an introduction, unlike a problem question where you don't start with an introduction, you start straight with discussing the first legal issue. In an essay question, you start with an introduction. For public law, we usually have essay questions, but I've seen some problem questions as well usually for judicial review. Make sure that you are prepared for essay questions that usually come up on the exams. In the introduction, we need to explain separation of power and cite the relevant academics that have talked about it, that are very important that have expressed very important insights that we usually study in law school, such as the l'esprit de loi and Aristotle concept. Separation of powers, a doctrine that has formed fundamental principle of constitutionalism in the US and in many European democracies, has never formally been incorporated into the Westminster model of parliamentary democracy. Although in the l'esprit de loi, when refining the Aristotelian concept of 3 things in all states, which a careful legislator ought well to consider, and expanding the importance of this tripartite division of power among the legislature, executive, and judiciary, Montesquieu based his formulation upon the UK constitutional arrangements until the end of the 20th century. Many scholars were profoundly skeptical about the applicability of the doctrine to the UK constitution. As you can see, not only we provided the definition of what is a separation of power, but we also introduced the issue at hand. The issue at hand, if you go back to the question, is whether or not UK has the separation of power, whether or not Constitutional Reform Act enhanced the separation of power. So in order for us to attempt to answer this question properly, we need to discuss if UK actually has separation of power and if Constitutional Reform Act has made the situation better or worse in terms of separating the 3 branches of parliament, of the government, parliament, and judiciary. Indeed, the lack of functional clarity between the core institutions of the country and traditional preference of fusion over the separation of powers became some of the main concerns that essentially prompted the passing of the Constitutional Reform Act. This is a perfect way of introducing the issue that we are going to discuss. UK has fusion of power. There is no strict separation, and this was the problem that triggered the passing of Constitutional Reform Act. So we first defined what is separation of power. Then we said that UK had a problem with complying with it because there was fusion. And then we said that this was the reason why Constitutional Reform Act has passed. Therefore, this is a perfect introduction for the examiner to understand that you are going to the right direction, you are discussing the right methods, right laws, and then you are going to give the right arguments. The Act introduced 3 key changes: reformation of the office of Lord Chancellor, the creation of the new Supreme Court, and establishment of independent Judicial Appointments Commission. Those are the 3 main changes that has been brought by Constitutional Reform Act that will be discussed in this answer. Thesis statement is what comes after the introduction, when you announce the plan of the essay, what you are going to say, what you're going to discuss first, what will come after, and where is your discussion going, what you are going to conclude. The essay aims to examine impact of each of these changes on separation of powers within the UK, and will demonstrate that despite minor controversies, the Act has modernized the existing UK practice in various respects and overall achieved its purpose of redrawing the relationship between the judiciary and the other branches of government. As you can see, we have here explained that what will be the main topic of discussion: changes on separation of power within the UK, and what we are going to lead our argument to. The conclusion we are making, the objective of this essay, is to show to the examiner that the purpose has been achieved of the Constitutional Reform Act, which was redrawing the relationship between the judiciary and other branches. Therefore, 3 reforms that we are going to analyze: reforming of the Office of Lord Chancellor, creation of the Supreme Court, establishment of Judicial Appointments Commission. Before 2005, there was no Supreme Court. Supreme Court purpose was assumed by House of Lords, which had obviously very big political influence over the highest decision-making authority in the UK court system. Therefore, it had to be separated. And Supreme Court was created after 2005 Reform Act. The first issue about reforming the Office of Lord Chancellor, seeking to reduce the reliance on a single channel of Lord Chancellor as a constitutional hinge between the judiciary and the executive. The Act has established multiple channels to mediate and negotiate the relationship between the 2 branches. So to start with, we have start by saying, what was the main purpose of reforming the purpose of this position, Lord Chancellor? A historic role of the Lord Chancellor, whose duties and titles were spread across each of the 3 branches of state, has long been seen as one of the most obvious and least justifiable overlaps of power in the UK Constitution. To address this issue, the Act removed Lord Chancellor's role as a head of judiciary and substantially reduced the powers associated with the status. Because the problem was that Lord Chancellor was a head of judiciary, so had a lot of power over the courts, as well as had political power. So there was an overlap, and it had to be reformed. Paradoxically, many feared that this removal would only weaken judicial independence. For decades, the office of Lord Chancellor had been occupied by the very senior lawyers, respected by both politicians and the judiciary, and the position itself had been perceived as a pinnacle of a successful legal or political career. The seniority of this position has encouraged the occupants of the role to be robust guardians of judicial independence. So as you can see here in the analysis part, we are explaining in more detail what was the purpose of Lord Chancellor and how was the role of Lord Chancellor perceived by political people in politics and in the judiciary as well. So what was the main role of this position, and what were the issues? This was the discussion of the first legal issue, which was about Lord Chancellor. In order for you to have a look at the other legal issues, the creation of the Supreme Court and establishment of judicial appointments, you would need to go to our website, this link, that you will receive the slides after the session, and read the full essay. I strongly encourage you to have a look at our full essay and read it in detail, because most likely you will get a similar question if you have an exam in public law. This is one of the most commonly examinable topics, Constitutional Reform Act and separation of powers. Also, I highly recommend you to have a look at our revision notes, cases, example essays, quizzes, and flashcards. Revision notes are a perfect summary of, in the simplest and condensed manner, of what you need to know to get a high grade. Our example essays give you an insight of how you are supposed to structure your problem and essay questions to get a high grade. All our example essays are at 2-1 or first class level. So make sure that you read them carefully so that you understand what you're expected to do if you want to get a high grade. Quizzes and flashcards are also a great resource for you to memorize the main legal principles and cases, especially important if you have a timed exam or if you have an in-person exam where you're not allowed to take your notes. All our content has been created by successful students and graduates who have recently been in your position and achieved very high grades in their relevant exams. So they understand all the struggles that law students experience, and all the content has been written taking into consideration all those struggles, making sure that we give you just the right information that we used to be successful and to achieve those high grades that you want to achieve. If our resources and your subscription is not enough, we highly recommend you to have a look at our tutoring services, which is a personalized one-to-one support with a tutor to help you with anything you may be struggling with in your legal studies. It can be anything from planning an assignment or practicing with problem and essay questions, your proofreading, even already written answer for feedback. Whatever you may be struggling with your legal studies, our tutors will be able to help you on a one-to-one Zoom meeting. We've already helped thousands of law students to get high grades, and many students who tutor with us regularly, as well as study with our resources, tell us that they get a first class. So you're highly encouraged to start studying with us as soon as possible so that you have enough time to prepare for your upcoming assessments. We would like you to be our next student to get high grades. Please join Simple Studying now, and please also join our WhatsApp groups where you can connect with the community and ask them any questions you may have.